I'm WDET News Director Jerome Vaughn. Candidates for president and Congress are crisscrossing the state, and WDET will give you a chance to hear some different perspectives on what's happening in our second Smart Politics event. Join me at the Rind in Berkeley on July 10th to hear Canton Township Clerk Michael Segrist, communications expert Matt Friedman, and others. There's more info at WDET.org/events.
2024 political coverage on WDET is made possible in part by Ruby Duffield, Marianne, and Carl Fontana, and listeners like you.
This nation was founded on the principle that all men are created equal.
We hold these truths to be self-evident.
That all men
are
created equal.
I'll tell you what freedom is to me. No fear. I mean, really, no fear.
Created equal.
From WDET in Detroit, this is Created Equal. I'm Stephen Henderson, and sitting across from me in the studio is Kerry Jr. II. He produces our show. Hey, Kerry.
How you doing, Stephen?
Good.
This is a long-awaited conversation.
It is. I've been talking for months about the idea of accountability for government officials and how we hold them accountable. I think it's something we struggle with a lot in this country, and we've been looking for the right way to kind of get into it. Like, what's the frame for talking about it? And I think we found it.
Well, I don't even know if it was finding the frame and the wording. I think you knew qualified immunity was the way you wanted to approach it. We just have to find the right person.
Yes.
To talk about it, right?
And the right time.
And
I kind of wanted us to think through how we talk about this, because qualified immunity is the thing that I think comes to people's minds when we talk about this kind of accountability,
right.
the way we hold police responsible for their conduct. But of course, there are lots of other things too that fall into this category, and we're dealing with some of them now in the country with the Supreme Court ruling about Donald Trump and how he can be held liable for things that he did as president. It's an area of tension in our republic, and I just want to get at how we resolve that tension.
Yeah, I mean, it also speaks to who is going to be held responsible and what role are you in, and how does that dictate whether you'd be held responsible or not, right?
Yes,
there are folks,
that's right.
there's a class of folks, government officials, that qualified immunity protects from doing certain acts that may not apply the same way if you're a regular non-government official.
Yeah. So we've got a really great guest. We did find the right person to have this conversation. Right. Joanna Schwartz is a professor of law at the UCLA School of Law, and she's the faculty director of the David J. Epstein Program in Public Interest Law and Policy. She is someone who has spent a long time thinking about government accountability and qualified immunity in particular. So I think she is going to guide us through a really great conversation about this. Joanna Schwartz, welcome to Created Equal.
Thank you so much for having me.
So I want to start with just some definitions, because I think when we say things like qualified immunity, sometimes there's a lot of confusion about what that is or what it means. Some people don't have any idea what it is or what it means. And then I think some people are just not clear about what the principle is, I guess, at work here. So I want to give you a chance to talk about qualified immunity and how it works in our country.
Sure. Well, qualified immunity is a protection from civil liability, meaning damages awards against police officers and other types of government officials. It's a protection that was created by the Supreme Court in 1967. When they created it, they talked about the importance of a good faith protection, or a protection for officers when they were acting in good faith, so that they wouldn't be overly chilled when they're doing their job by the threat of being personally financially responsible for settlements and judgments entered against them. Over time, this protection has gotten stronger and stronger and stronger. through a series of decisions by the Supreme Court. So I won't take you through every single step, but what was originally this good faith immunity for officers thinking they were following the law when they actually violated it, it is turned into a protection that has nothing to do whatsoever with the officer's intent. They can, in fact, act in bad faith and still get qualified immunity if there's not a prior court decision that has held nearly identical conduct to be unconstitutional.
And that constitutionality of the conduct plays an important role, right? So there is this idea of qualified immunity. It says, look, if you're a police officer or another government official and you're acting within the duties of your job and acting in good faith, you can't be held personally responsible, except where officials have violated a clearly established statutory or constitutional right. Can you talk about that part of it? I mean, what kind of limit is that, and I guess what kind of limit should that be?
Well, I would say that the Supreme Court has sent a lot of messages to the lower courts that the conduct, in order to be clearly established, there has to have been a prior court decision that has, under factually similar circumstances, said that the conduct was unconstitutional. So it's not enough, for example, simply to say that there are Supreme Court decisions that say it is unconstitutional to use excessive force. But the Supreme Court says those general principles are not enough. You need a factually similar court decision that has said that that conduct, this kind of force, the use of a taser, is excessive under these particular circumstances. And lower courts interpret that in somewhat different ways. I think that a court from Texas and a court from California may view how similar those facts need to be in slightly different ways. But there are many opinions, and actually both from Texas and from California, opinions that have granted qualified immunity to what seem to be clearly or obviously unconstitutional conduct, simply because there's not a prior court decision that is sufficiently specific. And one example that I often talk about is a case brought by a man named Alexander Baxter, who had burgled a home, or allegedly burgled a home. The police came. They saw him. He was sitting down. He put his hands in the air. "You caught me." And the police then released their dog on Mr. Baxter, who attacked him and injured him severely. He brought a lawsuit. And it is clear in the court where he brought this case that it is unconstitutional and excessive to use force on someone who has surrendered. Right. That is a general principle. But in the court's view, it was not specific enough. The prior court decisions weren't specific enough to say that it was excessive to use force under these precise circumstances. Right. And that's true even though there was a prior court decision saying it was unconstitutional to release a police dog on a person who had surrendered by lying down. In the court's view, the differences between that case where the person had surrendered by lying down and Mr. Baxter's case where he had surrendered by sitting with his hands in the air,
that's enough,
were sufficient enough to mean that the law was not clearly established.
I mean, there are lots of areas of law where, in fact, I feel like courts have taken kind of, general principles of constitutionality, of the scope of people's rights, and parsed them to the point where essentially they have no meaning, right? Adding layer after layer of requirement to reach the threshold where you can say that someone's rights have been violated to the point where it's almost impossible to violate someone's rights.
Yeah, and I am in a lot of conversations with people who disagree with me about qualified immunity and about police accountability more generally. And often in these conversations, um, the person who I'm exchanging ideas with says, "Well, do you actually want there to be a situation where an officer, believes that they're enforcing the law, and the law changes, and all of a sudden they're held
Right.
responsible? And do we want a situation where officers are constantly being faced with the threat of liability simply because the law has changed?" The fact of the matter is, I think that if the law changed, there would be other protections that made it difficult to win in those cases to begin with, including that the Fourth Amendment to the Constitution talks about reasonableness of searches and seizures at the time, given what the officer knew at the time. But also, I think that this idea I understand why people are concerned about this idea that officers all of a sudden would be faced with a new set of circumstances and the law will have changed and then they'll be responsible. But it simply doesn't reflect the way qualified immunity actually functions and the protections that it offers today. Yeah. And so when you look at what's actually being protected, the kind of conduct that's being protected, it really doesn't, it's very difficult, I think, even for people who are defenders of qualified immunity to justify its application in these cases.
I want to go back there and kind of hit that point a little harder. The Baxter case is indicative, I think, of the level of conduct that we're talking about here, right? We're not talking about, roughing somebody up a little bit while you're searching them. We're not talking about even the minor overstepping that you see sometimes officers engage. In a lot of these cases, we're talking about it's just brutality, right? I mean, this is misconduct that is violent and injurious, greatly injurious to the people involved.
Absolutely, and part of the point that you've just made is that qualified immunity, although qualified immunity takes up a lot of space in conversations about police accountability, and rightly so. I think it's an important topic, and I think there's an awful lot that's wrong with it. It's important to take account of and recognize that it's just one piece of the puzzle. Before you have qualified immunity be an issue, take Alexander Baxter's case, for example. Before qualified immunity is even an issue, a person whose rights have been violated has to find a lawyer willing to represent them, which can be difficult. In Alexander Baxter's case, he couldn't find a lawyer to represent him. He was incarcerated for this burglary, and no one would represent him. He represented himself. Wow. In trial and on appeal because there was no lawyer who would represent him. You have to craft a complaint. You have to explain what happened to you, which was not a problem for Alexander Baxter, but there are many other people, particularly people who have died in police custody, where family members often don't know what's happened to them. And drafting that complaint can be difficult. Then, and this is perhaps the most critical to your point, you have to prove a constitutional violation.
Right.
The time when qualified immunity comes into play are cases in which the court has said there is, in fact, evidence here of a constitutional violation. But qualified immunity means the right's not clearly established. So the way that qualified immunity comes into play in these cases are cases were situations where plaintiffs have already gotten past these other barriers. And another way to say this is we don't need qualified immunity to weed out so-called frivolous cases or cases involving an errant push or shove or cases involving a search where nothing really went wrong, because those cases would have been dismissed anyway for lack of evidence of a constitutional violation. Right. Qualified immunity only comes in to the more serious cases, to cases where there is evidence of a constitutional violation. And in those circumstances, to give an additional shield to government to say, even if you have violated someone's constitutional rights, you're still protected.
I mean, you almost, the image that you're painting there, almost, this is not funny, but it is. There is some, I guess, irony or humor to it. It's almost as if the police are walking around with a shield of invulnerability, right? That no matter what they do, no matter how they do it, no matter the circumstances under which they do it, the harm to them is so distant and so rare that it almost doesn't matter. I mean, you can kind of picture superhero kinds of cartoons that depict people who are just invulnerable to consequence.
Well, and I can't help but say right now that last year I published a book that collects all of this research about these many protections, and it is called Shielded,
right.
How the Police Became Untouchable, which is precisely that point. And I do try to make the point that it isn't just qualified immunity. There are so many different kinds of protections that are intended and described, justified as necessary to protect officers from too much justice in these cases. But also important, and I think this connected to something you asked before about whether this is how the protection of qualified immunity should function. All of these justifications that the Supreme Court and state and local governments have offered as basis for these protections really bear limited relation to how things actually work in these cases and in these decisions. And that's really what I've spent the past decade researching, taking seriously courts' justifications for qualified immunity and other protections and asking, is there really any evidence that we need these protections given the way these cases function in the courts? And I don't believe that they do.
Yeah. Okay, we're going to take a quick break. And when we come back, we'll continue this conversation with Professor Joanna Schwartz of the UCLA Law School. We're talking about qualified immunity, how it works, and whether it needs reform. We'll be right back with more Created Equal. We're back with more Created Equal from WDET in Detroit. I'm Stephen Henderson, and I'm really glad you've joined us. We're joined this hour by Joanna Schwartz. She is a professor of law at the UCLA School of Law and the faculty director of the David J. Epstein Program in Public Interest Law and Policy. She's someone who has studied the issue of qualified immunity, protection for police and other government officials quite a bit. Recently wrote a piece called The Case Against Qualified Immunity. I want to talk, Joanna, now about the justifications that you were kind of referring to in the first part of our conversation that people give for qualified immunity, and why they believe it's necessary, and what the goal, I guess, is of this doctrine. We were saying just before the break that the practical implication of all this is that it has created almost a shield of invulnerability around police, no matter what their conduct. But what is the legitimate goal that people would say qualified immunity should have?
Well, when the Supreme Court talks about qualified immunity and why we have this protection and why the court has expanded the protection repeatedly over the years, they offer, I think, three different types of justifications. One is a concern about officers' bank accounts, the idea that officers shouldn't be personally financially responsible for essentially good faith mistakes or violations that weren't clearly established. The second is that it's important to save the time of officers so that they aren't chilled or deterred from vigorously enforcing their job by the threat of the time and the burdens of being sued, sitting for depositions, having to participate in trial. And the third is a justification based on the idea of notice, that officers should be notified, should be on notice of the unconstitutionality of their conduct before they are held responsible for it. I've essentially taken each of those justifications to look to see whether they actually hold water, and I believe that none of them do.
You don't agree with any of those.
I don't, and it's not just sitting in an armchair and saying I don't agree with them. I've actually looked to see whether they make sense given the practical realities of litigation. I looked at 81 law enforcement agencies across the country over a 6-year period and asked how often do police officers actually financially contribute to settlements and judgments against them. And I found that 99.98% of the dollars were paid by local governments or their insurers, not officers.
So when an officer is found liable for misconduct, that officer almost never is digging into his or her pockets to pay for that.
Correct. And that is a protection that comes not from qualified immunity, but from what are called indemnification agreements or indemnification laws, which are laws or agreements providing that when an officer is sued, he or she is given a lawyer and any settlement or judgment is paid from the government's funds, not the officer's funds. So that's an employment provision or a state law that has no relation to qualified immunity in the way in which it is applied. So that takes the wind out of the sails of this idea about officers being personally responsible. Yeah. I've also looked at the time it takes to litigate qualified immunity. And in fact, I think the evidence suggests that litigating qualified immunity actually adds time to the litigation of these cases. Officers are able to immediately appeal any denials of qualified immunity. And so qualified immunity, when it's raised, actually adds time to the litigation of cases. And then to the third point about notice, this is in some ways the claim that boggles my mind the most. And the article that I wrote about this, I called Qualified Immunity's Boldest Lie, which is that officers actually know about the facts and holdings of court decisions that are deciding whether the law is clearly established or not. So we talked before about how the Supreme Court has said you need a prior case with factually similar claims in order to clearly establish the law, because officers need to be on notice of the unconstitutionality of their conduct. In reality, though, officers are learning the broad principles. The broad principle that officers should not use force against a person who has surrendered, for example. The kind of principle that had existed in Alexander Baxter's case, but the court said, no, you need to find a prior court case where a dog was used under similar circumstances. The fact of the matter is, officers would not have learned about the facts and holdings of that case had it existed. They would have been trained about the broader principle that you don't use force against a person who is surrendered. Right. And that is what they are on notice of. And so if we're talking about the importance of notice, either police trainings need to change completely, and hundreds of hours need to be spent training officers about the facts and holdings of specific cases, or we need to reconsider what qualified immunity doctrine is actually requiring.
Right. Well, and in many cases, these are things that aren't complicated questions, right? Someone's sitting with their hands up, surrendering. What's the reason to release the dog on that person? If somebody's lying face down and saying, "Hey, I'm not running, I'm not resisting," what's the reason for use of force? I mean, there's a sort of false, I think, play to the idea that these are hard decisions that we're dealing with, and that's not to minimize the work that police have to do. But in the cases that I see where this qualified immunity gets raised, it seems that these are very intuitive kinds of, almost like Sunday school lessons, right? These are not things you do.
And important to say, I agree with you, and certainly a lot of the cases that get, that have gotten attention are cases where the officer's conduct seems just completely beyond the pale. Another favorite is a case out of Fresno where officers stole money during a search, $250,000 of money, and the Ninth Circuit, which sits in California and other states, said qualified immunity because this conduct, while perhaps inappropriate, obviously inappropriate, clearly in bad faith, is not clearly established as a Fourth Amendment violation.
Stealing money.
Stealing money. And important to note also, in the conversations about qualified immunity, it's important to know what happens if qualified immunity is denied. It's not that the plaintiff automatically wins. It's just simply that a jury gets to look at these facts. Gets to decide. What we're taking away is not just the ability of a plaintiff to win, although that is certainly true. But it's not an automatic win. There is another crucible through which the plaintiff has to go, which is through a jury. And so all that we would be doing in eliminating qualified immunity or reducing its impact would be sending more cases to a jury who would then be entrusted with deciding whether the officer violated someone's rights.
Let's talk a little about the role of defending yourself in these cases where officers are accused of misconduct, and I want to get to the role that unions play in all of this, because I'm somebody who is a big supporter of organized labor. I'm a Detroiter by birth and by choice, and so much of the labor movement in this country was from here and is baked into our brains very early. But at the same time, I know that in this case, the unions play an important and powerful role in maintaining, again, this bubble of invulnerability around police officers. So let's talk about what does happen if a police officer is accused of misconduct, and the role the union plays in making sure that in some cases not much happens.
Yeah, so unions have played a big role in crafting this shield. I would say that their primary target has been limiting accountability and transparency within internal disciplinary processes. So if you look at police union contracts, often the terms of those contracts are negotiating for, or are the product of negotiations for time limits on the amount of time that can be taken to do an investigation, requirements that officers be able to consult with union counsel before answering questions, that they be allowed to review video before answering questions, that terminations or decisions against them be purged from their personnel records after a certain period of years, limits on what can be publicly disclosed, and those and other kinds of union negotiated protections end up making it very difficult to sustain disciplinary action against officers. And then in the rare cases when discipline can be imposed, these union agreements often create arbitration or other kinds of appeals provisions that make it even more difficult for those rare disciplinary decisions to stick.
Yeah.
So unions are very involved in crafting and strengthening those kinds of protections. And I like you, am sympathetic in general to unions and supportive of union work. What's unique about police unions and corrections unions as well is that the negotiations aren't simply for pay and overtime and those kinds of protections vis-a-vis their employer. They are actually protections that concern their responsibility for wrongdoing as they're doing their job. So it's protections against complaints by the people that they are supposed to be serving.
Yeah.
And that is a unique kind of provision in a union agreement that I think is what makes those parts of those agreements so troubling to me.
Yeah. If this were to look more reasonable, I guess it would not eviscerate the protection that police have. Is that correct? I mean, that's not what you're proposing. You're saying that we've gone too far the opposite direction, but you're not arguing. I just want to make clear that police don't deserve some consideration for good faith actions on duty and some presumption of that good faith.
Of course, no, I absolutely believe that, and yes, as you said, my view is that the protections have simply gone way too far in the other direction, based on what I consider to be unsubstantiated or unsupported claims about why all of these protections are necessary. Even if you got rid of qualified immunity altogether, you would have the protections that are already built into the Constitution, as interpreted by the Supreme Court, which protect against unreasonable searches and seizures, but allow reasonable searches and seizures. And again, that reasonableness is determined, according to the Supreme Court, by what the officer is facing at the moment under the circumstances. And the Supreme Court has said you can make a mistake as an officer and not violate the Fourth Amendment, so long as that mistake was reasonable.
Was honest, yeah.
Yeah, and I don't if we got rid of qualified immunity, that protection would still be there. I even would support and have supported legislation that was proposed in Washington State, legislation that was contemplated in Congress that kept qualified immunity, but said, let's make it a true affirmative defense, meaning a defense that the defendant needs to prove. Can the defendant can the officer point to a policy, a law, a decision, a training that suggested to them that what they were doing was right under the circumstances?
Where did you get this? Right.
Where did you get that you can release a police dog on a person who had their hands in the air? Do you have a law that says that that's okay? Were you given training that said that's okay? If you were given training that said that's okay, then we need to think about bringing a case against the city and the city's police department. But the idea that we're focused on a good faith defense by the officer, but it's the plaintiff's burden to find some prior court decision that nobody's ever, that nobody involved in the confrontation ever has read, to justify the officer's conduct truly makes no sense to me. But my goal is not to say that that there should be no reasonableness determination here. Right. It's just simply that the one that we have doesn't make any sense.
Yeah. Okay, we're going to take another quick break, and when we come back, we'll continue this conversation about qualified immunity with Professor Joanna Schwartz. Stay where you are. We'll be back with more Created Equal. This is Created Equal from WDET in Detroit. I'm Stephen Henderson, and our guest is Joanna Schwartz. She's a professor of law at the UCLA School of Law and the faculty director of the David J. Epstein Program in Public Interest Law and Policy. She teaches civil procedure in a variety of courses on police accountability and public interest lawyering. She's an expert on qualified immunity, which is the subject that we're discussing today. This idea of police really invulnerability to accountability for things that they do in their official conduct. Joe, and I want to start this segment talking about the kind of broader context here. We've been talking about police and policing. This idea of escaping accountability for things done in your official conduct has been in the news lately in another context.
You don't say.
Right? A few people have been talking about this. The Supreme Court, in its flurry of late-term decisions this summer, offered its interpretation of the immunity that presidents should have from prosecution for both official and unofficial acts, and I'm super curious, really, about your take on how they manage their way through that, and look, I covered the court for 5 terms in the early 2000s, and I'm really familiar with, of course, the justices and the way they think and the way they manage through these things. I have a more nuanced, I think, reaction to what they did than some of what I saw, but it does seem to reinforce some of what we're talking about with this idea of invulnerability, and it certainly errs on the side of giving an awful lot of leeway to the person who's in charge.
It does indeed.
Did I say that diplomatically enough?
You did more diplomatically, I think, than I would have. One point to make. I have a couple points, but one thing to note at the beginning is that the immunity that the Supreme Court gave to presidents is an immunity from criminal prosecution. Yes. And one thing that people often misunderstand about qualified immunity for police officers and other government officials is it only applies to civil claims,
right.
To civil claims seeking money. There is not a immunity along those same lines to protect officers and other government officials from criminal prosecution.
The law. That's right.
Correct. For potentially going to jail. Now, there are heightened standards. It's very difficult to criminally prosecute an officer for a variety of reasons, but it's not qualified immunity. Now, what the Supreme Court did was give presidential immunity from criminal prosecution. Mm-hmm. So it is a wholly different realm of protection. And I guess I would note a couple of things. One is that many of the justifications that are offered by the court for why this immunity was so important sound in the same kinds of justifications that the court has previously offered for qualified immunity, namely, the need to not chill the president in doing their job, the importance of not taking up the time of the president, and sort of these claims about the burdens of being hailed into court on these kinds of claims. So that's one similarity. A second similarity is that the court, as I have said before, the Supreme Court's qualified immunity doctrine and cases really is based on no understanding of how these cases actually work in the real world when they throw around concepts like officers being personally financially responsible for settlements and judgments. In these cases, they don't recognize that officers virtually never pay. In some ways, the Trump versus United States decision is that on steroids, because the court is saying, well, we need to have presidential immunity so that presidents aren't afraid to give up office, when actually we had a president who was, in my view, working to undo the effects of a proper election without the protections of presidential immunity. So we have, N of one president who was trying to hold on to power in a way that was violative of the law, in my view. And so the idea that they needed, that he needed, or a president would need presidential immunity to agree to not be president any longer doesn't have any connection to reality. And the third similarity, I would say, or are we at the fourth, between qualified immunity and this case, is that they are both really created out of whole cloth. There is no basis in the Constitution for this kind of protection, and there was no basis for the Supreme Court's creation of qualified immunity either. So there are a lot of conceptual similarities, I would say.
And in fact, that assertion that there is no basis for this, that the Constitution really does not provide for this kind of protection, was also in the news recently this spring, I believe. There was a ruling by a lower court that found that there is no basis for this. Is that right?
Yeah.
And this was
a very thoughtful decision by the D.C. Circuit.
The D.C. Circuit, yeah. And what did they say in that case? And talk about why they're an outlier in the legal system. Well,
I'm not sure which you. I would say that the D.C. Circuit was not an outlier. The Supreme Court is the outlier to my view, because when this case has been making its way through the courts, I would say that the prevailing view by people much more schooled in the presidential power area of the law than am I, were very, very confident that there is no basis for presidential immunity. And you don't have to take their words for it. I mean, Mitch McConnell, when the impeachment of Trump did not move forward, Mitch McConnell himself talked about the availability of criminal prosecution as an alternative to impeachment. You could go back to Nixon being pardoned in order to avoid criminal prosecution. That was that pardon was not without purpose. There was an understanding of the possibility of
the likelihood,
impeachment.
Yeah, right.
So, of prosecution. Yeah. So the idea that Trump or any president could be immune from prosecution, I think, was not taken seriously by in many legal circles. Certainly in the legal circles that I'm privy to, and the expectation, among some court watchers was that the Supreme Court would, for example, have said that Trump could stay on the Colorado ballot, which he did, which was another case that was pending, but say that he was not immune from prosecution. But I think after the oral argument, the people's predictions began to shift.
Yeah.
So I would say the Supreme Court, in my view, is the outlier here, not the D.C. Circuit.
But at the same time, when I talk to people about this, I think there's maybe an existential divide on these questions generally, right? We like the idea of holding people accountable for their behavior, right? Our entire, not just criminal justice system, but the civil system the civil legal system is convened around the idea of that accountability. But I think as Americans, we have a hard time applying that to authority in quite the same way. And I can think of lots and lots of examples, where that seems to play out. One of them is here in the state of Michigan, where we had a governor who 10 years ago, made a decision that switched the water supply in Flint, Michigan, and as a result, everyone in that city was exposed to lead poisoning through the water. We've had a terrible time trying to figure out who should be held responsible for that because it's a governor, right? If that were an ordinary citizen, I don't think anyone would have a question about that. And I guess I wonder what you think that is. What is it about us that doesn't want to hold people in power as responsible as everybody else?
Well, I think I'd like to think that people agree, at least in theory, that someone should be held accountable. To return to some of these conversations that I've been having actually recently with folks who disagree with me greatly on qualified immunity. Would still say that when police violate the law, they should be held accountable, or the local government should be held accountable. That there is this idea that accountability is important, at least in concept. But then when you get down to the brass tacks of figuring out who is to be held accountable and how, I think that's where we often disagree. And my hope is that getting a little more specific about the actual information about what has happened, what effect these cases have, what effect various decision makers have, could reach more agreement on these points. I do think that when you're talking about a decision like changing the water supply in Flint, and frankly, to return to qualified immunity decisions, if you're or government liability, if you're thinking about who's responsible for an officer releasing a police dog on someone who has surrendered, there's the person sort of at the tip of the spear, but then there's the mechanics, the bureaucracy behind it that has sort of allowed through benign neglect or reckless indifference or whatever term you want to use, the culture to continue and to tolerate this kind of conduct. It's not the governor acting alone. There's a whole bureaucracy that is enabling this kind of mistreatment to occur. And I think, in some ways, it becomes complicated to figure out how to hold someone responsible when what we're really talking about are systemic harms and systematic harms. And I think that is more complicated, but it's also a deeply important assessments and reckonings to be having, because ultimately that is where I think change can occur at the highest levels.
Okay, Professor Joanna Schwartz, it was really great to have you here for this conversation. Thanks so much for joining us on Created Equal.
It's my great pleasure. Thank you so much for having me.
That'll do it for this edition of Created Equal. Remember, you can listen to recent episodes of the show at WDET.org. Check us out on Apple Podcasts, on Spotify, or wherever you listen to podcasts. And while you're there, don't forget to subscribe and to rate the show. You can also leave us a review. If you like what you hear from our WDET programming, please support the station. We are always taking donations. And to do that, you just head over to our website and click the donate button at the very top of the page. Created Equal is produced by Carrie Jr. II and David Lines. Our audio editing is by Connor Anderson, and the music is by Sam Bobian. Created Equal is a production of WDET, a listener-supported service of Wayne State University.